You're tuned in to Agriculture Today, and we start our Wednesday show talking about the Swampbuster Act. And then to talk about it, we're joined by K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Thank you for having me, Shelby.
Roger, you recently wrote a blog article titled, "What's Going On with Swampbuster?" And before we talk about what's currently taking place around it, first a little bit of history and how did this concept get started?
Well, Swampbuster came in with the 1985 Farm Bill that had all the conservation cross-compliance provisions in it. And it came in as well with Sodbuster. Those were two of the major programs that were put in 85, as well as the Conservation Reserve Program. So a lot of conservation-type provisions that were included in the 1985 Farm Bill. And what it says basically is that you're not going to receive and be eligible for federal farm program payments if you drain land that is deemed to be a wetland, in accordance with the USDA rules, to produce an agricultural crop on it. So that's the basics of what Swampbuster is and where it came from.
What is distinguished as a wetland?
Well, initially, there were some interim rules that were put out in June of 1986, and wetland under those rules was assumed to be truly wet ground that had never been farmed. And there had to be an obligation of funds, such as an assessment paid to a drainage district that would qualify it as a commenced conversion. And so, therefore, if it had already been commenced in terms of being converted from a wetland to cropland prior to the effective date of the 1985 Farm Bill, you could still farm that and participate in the federal farm programs. Final rules came out in 1987. They were vastly different than the interim rules, and basically a lot more restrictive with respect to the application of the rules to farmers. You couldn't keep certain land in production that you could have under the interim rules, the way the final rules were written. And there were a lot of different aspects to that, but basically the rules became much tighter under the final rules.
And did the difference between the interim rules and final rules really make a big impact for producers?
Yeah, they did, and I think probably the biggest impact had to do with prior converted wetlands. They can be farmed, but they revert to their protected status once they were abandoned, and abandonment could occur after 5 years of inactivity and could have happened even in 1 year if there was an intent to abandon. And so under the final rules, a prior converted wetland, which means you're not subject to the Swampbuster rules, is a wetland that was totally drained before December 23, 1985. That's the effective date of the 1985 Farm Bill. And it's a wetland that is manipulated for the purpose or with the effect of making production of an ag commodity possible if that production would not have been possible but for the drainage activity. So the other problem that the final rules gave us was the concept of a farmed wetland, and that's a wetland that was drained before the 85 Farm Bill took effect, but still had wetland characteristics that remained. If that's the situation, then only the original drainage could be maintained. Now, once those rules came out, Shelby, we've had a lot of litigation on a whole host of issues with respect to Swampbuster. So it's been kind of a minefield for attorneys that practice in that area of the law, which is the case anytime you have a government program with rules associated with it. The question is whether you qualify for an exemption under the rules or whether the rules actually apply to you or not.
And a provision that also came with the Swampbuster Act, the Grassley Amendment?
Well, it didn't come exactly with the 85 Farm Bill. This one came in 1990 as an amendment to the Swampbuster rules. And it provided a review provision specifying that a prior wetland certification was to remain valid and in effect until such time as the person affected by the certification, which would be a farmer, requests review of the certification by the Secretary. That's what the Grassley Amendment said. It was named after Senator Grassley of Iowa, who is still there, by the way. So the purpose of the amendment was to prevent farmers from being subjected to multiple certifications based on new methods that at the time NRCS had started using to make wetland determinations, such as aerial photographs to make a wetland determination. And under the rule, a farmer could request a recertification. They could ask the NRCS to come out and make a recertification of a prior certification to see if things had changed and whether a wetland was no longer a wetland. Now, what happened was, of course, NRCS wrote regulations to carry out that statute. And they said, well, yeah, it says a farmer can get a recertification upon request, but we can't do all of those upon demand like that. So we're going to put the burden on the farmer to say that, well, yes, we'll come out and recertify, but only if a natural event altered the topography or the hydrology of the land, or if NRCS believed that the existing certification was erroneous. That then got into a court case, and that court case is presently sitting at the Supreme Court waiting for them to decide whether they're going to hear it.
And that case called the Foster case, and kind of what heartache did that family and that operation feel with this?
Well, this is the Foster case comes from southeast South Dakota, and this involves an 0.8 of an acre portion of a field that USDA certifies as a wetland in 2011 under the Swampbuster provisions. And the wet area, when it had water in it, was about 8.5 inches deep at certain times of the year. Now, the interesting thing about this was that the wetland resulted, or the supposed wetland, I should say, resulted from a tree belt that had been planted in 1936 by Foster's predecessors to prevent soil erosion. So it's caused by trees that were planted to preserve the soil. Well, the snow in South Dakota accumulated around the tree belt in the winter, it melted in the spring, and sometimes you'd have water that would collect in a low spot in the field without any drainage. It would have to soak into the ground or evaporate. And that happened about half the time, and it would dry out in time for planting. In other years, it had to be drained to plant crops. Well, Foster wanted a review of the certification that USDA had done or NRCS had done, and they basically, in essence, there were some machinations, but they refused to do that. And he again sought review of the certification in 2017, and USDA, NRCS didn't respond that time on the basis that he didn't provide any new information. Well, his argument was, I don't have to do this. This is not required by the statute. The statute says I have a right to request certification. You have to do it. And the USDA was saying, but we wrote regs that say that you have to show changed circumstances or that we made a mistake. And you can do that, so we're going to ignore you. So that's how this ended up in court. So far, he has lost, and the lower courts have said that the agency's rule writing was within their purview, so they gave them deference on that. And this case currently is sitting there on a request for the U.S. Supreme Court to hear it. And at their conference in January, the U.S. Supreme Court didn't do anything with this case. They didn't say yay or nay. And I think they're holding it, Shelby, until they decide two major cases involving agency deference that they will decide probably in June. So after that, if they lower the deferential standard given to federal government administrative agencies, then I think they will hear the Foster case, and we will get a ruling on the Grassley Amendment. If they go the other way, then we won't hear the Foster case. At least that's how I read the tea leaves right now.
And Roger, there is another case that was recently filed involving the Swampbuster Act as well.
Yeah, this one was filed in Iowa in mid-April, and this is a frontal challenge, a frontal assault on the constitutionality of the Swampbuster program as a whole. There are really 5 claims in the case. One, that it violates the Congress's power under the Commerce Clause because the 9-acre wetland in that case is purely inside the state of Iowa and has no connection to interstate waters at all. And so there's no interstate commerce that's involved. Therefore, the Commerce Clause does not invoke congressional power, and the act is unconstitutional as a result of that. Also, they're claiming that the Swampbuster rules impose unconstitutional conditions by conditioning a government benefit on the waiver of a constitutional right. They also say that it amounts to a taking of their private property in violation of the Constitution that the government has to pay for by granting the government a permanent conservation easement over their 9 acres without paying for it, and that the Swampbuster regulations exceed the authority that NRCS has as a government agency by adding what's called woody vegetation to the statutory definition of converted wetlands. And then finally, they say that the regulations exceed the agency's statutory authority and by doing so violate that Grassley Amendment. So this is a second case that also involves a claim involving the Grassley Amendment.
Is this something then that hopefully we'll get answers to what people are feeling on the Swampbuster Act by the end of 2024?
Well, we'll see. We may have a trial court decision by the end of 2024, but I would imagine whatever side loses will appeal it, and then it would go on to the 8th Circuit, and we could be easily into 2025 or 2026. if it goes all the way to the U.S. Supreme Court, we could easily be into 2027 by then.
And Roger, always wanting to remind people where they could read more on this topic.
I have an article on this posted on my blog, which can be accessed through my homepage, which is washburnlaw.edu/WALTR. It can also be found on the Ag Manager website through the Department of Ag Econ at K-State.
Roger, I appreciate you taking the time to join us today and give us an update on the Swampbuster Act.
Thank you very much, Shelby.
That was K-State and Washburn law professor Roger McEowen. I will link his blog article titled What's Going On with Swampbuster in today's show notes on agtoday.net.